I rise on a point of order, understanding Order 83 and 218, subsection 2, to seek your guidance on the status of bills to amend the Constitution that are at different stages of consideration by this House, and the legislative proposals that are pending before the Departmental Committee on Justice and Legal Affairs for pre-publication scrutiny. Mr. Speaker, I ask this in the light of the judgment of the High Court and the Court of Appeal in the Constitution of Kenya Amendment Bill 2020, the BBI Bill on the Basic Structure Application. Honorable Speaker, to refresh the mind of the members in this House, the High Court and the Court of Appeal decision on the BBI Bill did uphold as follows on the basic structure. One, that the basic structure doctrine is applicable in Kenya. Two, that the basic structure doctrine limits the amendment power set out in Articles 255, 256, and 257 of the Constitution. Three, that the basic structure of the Constitution can only be altered through primary constituency power, which include 4 sequential processes, which are civic education, public participation, constituency assembly, debate, and a referendum. Honorable Speaker, as you are further aware that there are at least 7 published bills proposing to amend the Constitution before the House, which are at different stages in the House. And the Speaker, the bills include: 1, the Constitution of Kenya Amendment Bill 2019 by the Honorable Florence Mutua, the Constitution of Kenya Amendment Bill number 2 of 2019 by the Honorable George Kariuki, the Constitution of Kenya Amendment Bill number 3 of 2019 by the Honorable Gladys Boss Sholei. 4, the Constitution of Kenya Amendment Bill number 4 of 2019 by the COIC Committee, the Constitution of Kenya Amendment Bill number 5 of 2019 by the COIC Committee, the Constitution of Kenya Amendment Bill number 6 by the Honorable Vincent Kemosi, and number 7, the Constitution of Kenya Amendment Bill by the COIC Committee. Honorable Speaker, in summary, these bills amend various provisions of the Constitution and provide, among others, A, change of timelines of nomination of members to Parliament so that it is done after the general election. 2, include Kenyans diaspora as special groups under Article 97. 3, increase in the number of elected women members of the National Assembly from the current 47 to 136. 4, amend Article 152 to provide that the President shall appoint cabinet secretaries from among members of Parliament. And 5, amend Article 90 of the Constitution to make provisions for political parties to nominate to the National Assembly and the Senate presidential and deputy presidential candidates who lose in the general election. Honorable Speaker, there are also several legislative proposals to amend the Constitution that are pending before the Committee of Justice and Legal Affairs for pre-publication scrutiny, or before the Budget and Appropriation Committee for financial analysis. Mr. Speaker, some of them touch on various items, including the establishment of the position of a Prime Minister, his 2 deputies, who shall be from the largest political party in the National Assembly, and to provide that the Prime Minister and the 2 deputy Prime Ministers shall be appointed by the President with approval of the National Assembly. Honorable Speaker, looking at the proposals for amendments as contained in these pending bills and legislative proposal, it is clear that they contain matters that were contained in the BBI bill, which has since been declared unconstitutional. To this end, and in the light of the judgment of the High Court and the Court of Appeal in the Constitution of Kenya Amendment Bill 2020 on the basic structure, this is to seek your guidance on the following, Mr. Speaker. 1, what is the effect of the judgment on the various bills to amend the Constitution, which are at different stages in the House, and legislative proposal, which are yet to be published in terms of the basic structure application? 2, Mr. Speaker, how is the question of the basic structure to be determined, and at what stage of a bill shall that determination be made? 3, could it be prudent for the House, Mr. Speaker, to suspend any further processing of these bills and legislative proposals until a determination is made on the application of the basic structure doctrine on each of them, and a legal framework on review of the Constitution of Kenya is developed? Honorable Speaker, it is notable that the courts agreed with your considered rulings, Mr. Speaker, in particular that a bill to amend the Constitution under Article 256 and 257 cannot be amended, that corrections and errors may be effected as they are not amendments, and that there is definitely a fundamental lacuna on the processes under Article 256, which is parliamentary initiative, and Article 257, amendment through a popular initiative. So, Speaker, the courts on this matter have agreed with your ruling and communication that you gave to this House. Honorable Speaker, you have ruled before that Parliament should not act in vain on a number of your rulings. And in this regard, Mr. Speaker, I respectfully hold the view that we should not spend time of this House and its committees considering bills and legislative proposals to amend the Constitution only again for the courts to fault the outcome for not following the just process due to lack of sound legal framework. Setting up the legal framework, Mr. Speaker, is the business of this House and the Senate. Honorable Speaker, so that we don't put the cart before the House or before the horse, could I be in order to request you to once again rise to the occasion as you have always done and use your powers under Standing Order number 1 and Standing Order 281-2, subsection 2, to ask the COIC, Justice and Legal Affairs Committee, to formulate a bill to actualize the provisions of Article 256 and 257 with its specificity. I ask you that, Mr. Honorable Speaker, conscience that this task could be better undertaken by a committee and not an individual member due to its magnitude and enormity. Indeed, Mr. Speaker, both the High Court and the Court of Appeal did uphold that there exists no legislation to govern the popular initiative process, including the matter in which the verification of signatures was to be conducted. Should this not be the first step, Honorable Speaker, before all this can be considered by the House? Finally, Mr. Speaker, I have in mind a bill close to the Constitution of Kenya Review Act, Cap 34 of 208, which could provide the form, among others, the legal framework for the amendment of the Constitution under Article 256 and 259, the mechanism and the responsibility of undertaking signature verification, civic education, public participation, constituency assembly debate, all found under Articles 256 and 257, among other things. So, Mr. Speaker, as a ranking member, I have seen a lot happening out there that people want to engage the House and its committees in trying to amend certain provisions of the Constitution. And Mr. Speaker, based on the ruling of the courts at both levels, it is imperative that with the introduction of the concept that the structure, the basic structure doctrine is applicable in the amendment of the Constitution. And Mr. Speaker, to be more specific, the basic structure doctrine touches on the function of Parliament. So, Mr. Speaker, when you want to add the number of women members of Parliament from 47 to 130 plus, it touches on the function of Parliament. The basic structure doctrine within the reading of the court touches on the Bill of Rights, on the judiciary, and the executive. Those four key areas have been cited as the anchors of the basic structure document. So, Mr. Speaker, so that we don't take this House into a limbo and do a lot of stuff that will not see the light of day. Because, Mr. Speaker, we spent resources, time, and energy on this animal called BBI. And today, we are back to square zero. We don't want the same shenanigans and the same issues to be taken through this House. So, Mr. Speaker, you have risen to the occasion a number of times. We will ask you to guide this House, Mr. Speaker, and even ask the leader of majority that I think the first thing on the table before we do anything else, let us dispose of and ask even the Senate to dispose of very fast the bill, I think, that was supposed to set the process of the referendum, the legal framework on these signatures. So, Mr. Speaker, I beg to submit and request your considered ruling, and I'm sure you have enough time between now and 21st before we come back. So, Mr. Speaker, we really want you to make a ruling, just like Judge Odunga and Judge and his team, just like Judge Musila and his team. Mr. Speaker, Kenya must remember you. Kenya must remember you, Mr. Speaker. You are coming at the tail end of the term of Parliament. I am sure those judges, the 5 and the 7, both in prominent law schools in Kenya and globally, their judgment will be celebrated. Their judgment will be used as an authority for many postgraduate law students on constitutionalism. Mr. Speaker, Speaker Muturi has been known for his ruling. Mr. Speaker, I want you to join the ranks and the file of those 12 judges and make a ruling. And you come from the judiciary. Join your colleague in protecting this House from those who want to bring amendments. Please protect the House and tell this House that the interpretation of the doctrine, the basic structure doctrine is applicable, because this House is not outside the framework of this, our boundary. Mr. Speaker, rise to the occasion, use standing order 1, use standing order 218, and subsection 2. Mr. Speaker, I have, in preparing these arguments, Mr. Speaker, I have gone into the many rulings you have made. You know, Honorable Rachel, when you say it's enough, you don't know how much time I've spent in reading this and studying this. So if you did not do that, then you have your space and sit down. Let me finish. I spent time to study this. It's not something, I'm not arguing on a pedestrian argument. My argument is based on law. So you should give me my space, and the Speaker will give you a time, if at all you have done a research. So, Mr. Speaker, this matter, I have looked at it, And I've seen the bills, I've read the bills, and I've said, how do we move? And Mr. Speaker, finally, Mr. Speaker, when I was the leader of majority, Mr. Speaker, and you are my witness, a number of pieces of legislation were annulled by courts, by the judiciary. Some of them on the basis of public participation, some of them on many reasons. So I'm not talking from a dark room, I'm talking from experience. So we don't want to go and engage and use resources of this House into the shenanigans and the intimidation and the bribery and the coercion that was synonymous with the BBI train. We don't want that again, Mr. Speaker, to be brought. I submit and wait for your considered ruling when we come back, Mr. Speaker. Thank you, Mr. Speaker.